To grasp just how impossible it is to know whether your work, lost among millions, has been swallowed into an AI's training data and dissolved into its algorithmic soup, listen to this short debate of experts that we've prepared for the Glitch Lounge.
Welcome to The Debate. Today, we're diving into Australia's decision, the one explicitly ruling out a copyright exception for text and data mining, TDM, especially for training AI models.
Right, and the core question really is whether this Australian law can actually give creators meaningful protection and compensation, given that so much AI training and data scraping happens all over the world.
Exactly. And I'll be arguing that, yes, this decision does provide that essential legal foundation and leverage for creators to get compensated.
And I'll take the view that, well, laudable as the principle is, its real-world effect is pretty limited by jurisdiction and just the technical facts of how these huge AI models are built and operate globally.
Okay, so my position is this. The decision is actually a crucial win for Australian creators. By specifically denying that TDM exception, the government's made it clear that unauthorized commercial TDM using local content is, well, illegal here. That fundamentally shifts the conversation towards compensation. It gives creators actual legal backing, a leg to stand on when demanding payment. And maybe more importantly, it pushes for the creation of these paid collective licensing systems that AI companies will likely need to engage with if they want to use Australian data cleanly and, frankly, reduce their legal risks worldwide.
Okay. I understand the point about the legal framework changing domestically, but I think that effectiveness just kind of evaporates when you look outside Australia. Jurisdiction is the real sticking point here. Australian copyright law, well, it generally only covers copying that happens in Australia. But the really big foundation models, the ones from, Google, OpenAI, Anthropic, they're trained overseas. They scrape data globally. So our law struggles to actually reach the main players doing that initial massive data ingestion. It's happening outside our legal reach.
I'm not sure I agree it completely evaporates the leverage, though. Even if the main training happens offshore, think about it. Making the non-payment route clearly illegal in Australia gives creators here significant negotiating power. And importantly, companies that distribute AI outputs in Australia that infringe copyright, they are still exposed to lawsuits right here under our jurisdiction. So the pressure to cut licensing deals to get legitimate access to data is definitely heightened. Legal uncertainty, even if it's only partial uncertainty related to Australia, it's still a very expensive risk for these big tech companies.
Expensive risk, perhaps. But the leverage argument only really works if creators can actually prove infringement. And that's where I think the technical problems become almost insurmountable, especially for individual creators or smaller groups. How do you enforce this? The core act, the training, is often offshore. And once the works are ingested, they become part of this black box of mathematical weights. It's often called the granular soup. Proving exactly which bits of your Australian work went into that model's weights, and then showing that a specific output is an infringement derived from it. That's incredibly complex technically and likely prohibitively expensive legally. And there's another layer to this. What about all the scraping that's already happened? Huge amounts of online content have been scraped by these foreign companies for AI training before this ruling even came into effect. For all those works already sucked into the datasets, this Australian ruling can't retroactively uncopy them. So realistically, aren't we mostly just talking about potential future activity within Australia, which kind of minimizes the immediate protection for works already out there and used?
Yeah. Okay, that limitation for past scraping is definitely real. I grant you that. But look at the momentum this legal certainty has created. It's actually driving market-based solutions even for that historical stuff. We're already seeing industry groups here pushing the government to set up separate compensation schemes, specifically to pay creators for works already used by those overseas trained AI models. So the ruling didn't just aim to lock down future use. It seems to have sort of jump-started the whole conversation about figuring out retroactive payment, too. It created the pressure. So ultimately, I think the ruling is achieving its core aim. It makes unlicensed TDM illegal domestically, it secures that fundamental principle that creators should have control and give consent, and it forces the issue, pushing towards creating workable market solutions, licensing, and compensation schemes.
The principle of consent is definitely stronger now, yes. But we still have to face the sheer complexity of getting comprehensive enforcement and compensation. You've got the global jurisdiction puzzle, the fact that so much data is already scraped and out there, and this really difficult technical and legal challenge posed by the granular soup. So, while setting the domestic legal principle is a necessary step, actually getting widespread compensation from the major overseas players, that's going to need, well, a lot more than just this one Australian decision.
And I suppose grappling with those points, the jurisdiction, the technology, the global scale, it really highlights the fundamental tension, doesn't it? The limits national laws face when dealing with something as borderless as the global data economy and AI development.
Hit that subscribe button for the latest updates on copyright clashes, creator rights, AI tutorials, and the algorithms shaping our future. See you next time.